are warning that the looming court challenges against the recently signed Electoral Act will have implications for South Africa's 2024 general elections. The One South Africa movement filed papers in the Constitutional Court on Friday over the Act. Michael Louis is the chair of the movement, and he joins us now via Zoom. Michael, thanks for making time. What are you challenging about this Electoral Act? What are your concerns?
Thank you, Clement. Well, the big thing is that for the period of 2 years that we've been participating in the process of electoral reform, we've really focused as One South Africa movement on two issues. And the one issue is the whole issue of the high barriers to entry. And that was the thresholds that an independent candidate needs to get to acquire a seat, but as well as signatures. And I'll just explain to the listeners a little bit more about that. And then the second issue is the recalculation of the votes, that when it comes to a political party and there's a vacancy, a person dies or resigns, then the next person on the party list fulfills that seat. But with an independent candidate, there's only one person. So we don't agree and believe that what the Electoral Act sort of portrays about how that vacant seat will be fulfilled, and we believe is unconstitutional. So those are the two main issues.
So in essence, it favors the political parties and unfair on independent candidates.
Well, the big thing is that the problem that the Parliament has got with this whole issue, they've always seen it as an administrative issue and not a human rights issue. And we believe that in the human rights of the Constitution, us being a constitutional state, there should be no difference between a political party and an individual person. But the way the Act is written, that there is a huge difference. So let me give you an example on the signature required. So what in the past, if you were a political party and you wanted to take part to become a member of Parliament, you needed to get 1,000 signatures so that you can show that at least you've got some form of support. And we believe that's important. But what this new Act has done, it's divided South Africa into regions, and just in one region, an independent candidate that must stand in Gauteng alone, just one of the 9 regions, needs to get 13,200 votes, where in the past it was 1,000. Now, for one thing, it is to say that an independent candidate must get 13,000 votes. It sounds like just a number. But what happens is that independent candidate, and say, for instance, it's going to take 5 minutes per person to register and get a signature, will need 6 people permanently for 6 months just to get those 13,000 signatures. Now, how's that empowering? How's that equal protection in the law? And so it is something that we feel extremely strong about.
Yeah.
The same thing is with the same thing, Clement, about vacancies is that we suggested to Parliament that independent candidates should have a running mate. That before the elections, if I resign, for instance, my seat, or I die, I must be able to tell my constituency that Clement will be the person that fills my seat. They didn't allow it. They said there must go and be a recalculation. And the figures show from our professionals and our actuaries that we've submitted that the bigger parties are the ones that will always take in recalculation, will take that vacancy. And so we believe that that's unconstitutional.
Yeah. What challenges do you think this presents for the IEC? Because when the Electoral Commission prepares for the elections, it requires at least 24 months to prepare for the elections. So the uncertainty that has now risen as a result of the court challenges will no doubt create great difficulties for them, because they've got to prepare logistics, they've got to train the electoral staff, and they've got to make sure that all the other processes in the electoral process are catered for.
Well, as One South Africa movement, it's very, very important for us to be seen as a constructive movement. And of course, we understand the dilemma that we are all in. But we're an advocacy movement that wants equal protection in front of the law, and we are a constitutional state. What is the difference if we go now and challenge the Constitution rather than having a full election? We spend 800 million, the IEC runs a perfect election, and then when one of the political parties believe that they didn't get the results they wanted to have, I can promise you that they'll be the first to challenge it. So whether the IEC likes it or not, this bill needs to be challenged and goes through the Constitutional Court. The second thing is I just wanted to say is that I've personally been involved on behalf of OSA and my colleagues. We've attended 30 meetings, parliamentary meetings, and everything that we've said in our papers, we warned them from day novo, from the first meeting. We personally saw the IEC to caution them. We personally petitioned the President in March this year to say, this bill is unconstitutional. Please don't sign it, send it back to Parliament. It fell on deaf ears. Unfortunately, we've done our part. We sleep very nicely at night to say, let the courts decide what is right and fitting.
Yeah. We're operating within a very tight time frame now. So if the current Electoral Act is also declared invalid, what's the next step? Does the IEC then approach Parliament and then request it to change the Constitution in order to allow them to have an election outside the constitutionally stipulated period?
Well, it's not the IEC. So what we've done in our papers, we've tried to, we really understand the legislative powers, and we don't want people to overshadow that the Constitutional Court doesn't impede on Parliament's work. So what we've done in our papers, we've really made excellent solutions. We've just stopped short of a writing-in clause where we've made it easy for the Constitutional Court to make a directive to Parliament to say, listen, we're not going to give you a judgment of how the Electoral Act should look like, but we're going to make a judgment of what's constitutional and not constitutional and give you a directive of how the Electoral Act must look like. We, as the Constitutional Court, are sending it back to Parliament. You must redraft the Electoral Act and send it back to do. And that's why OSA is doing it as an urgent application. We've given 15 days for the opposition parties, which is the President, the Speaker, National Council of Provinces, to reply. And we hope to get into the courts very soon.
Okay. Why do you think parties voted for this bill as it currently stands?
Well, I mean, the big thing is I think that they tried to do their best, but I must put a lot of the blame on a lot of the stakeholders that participated in this process. I can tell you now that civil society played an incredible part in submissions, warnings, and warning Parliament that this bill is not constitutional. Unfortunately, we had the legal advisors of Parliament, we had the legal advisors of Home Affairs, we had the legal advisors of the President, all raising their hands to say that this bill is constitutional. So I feel sorry for the parliamentarians. What do? If their legal advisors and their custodians are saying that this bill is constitutional, I really don't know what to do. We've warned them. We've submitted senior counsel opinions right from the beginning. I can tell you now, it's a very weak bill. It's very disappointing. The public will not have the credibility in the elections. It needs to be challenged, and it will be challenged.
All right, Dr. Michael Louis, Chairman of the One South Africa Movement, thank you for making time for us.